we just got a pretty major update in the case of the Salvadoran man, Mr. Abrego Garcia, who's being held in a Salvadoran prison, and I wanted to catch you up. The Fourth Circuit Court of Appeals just released its response to the government's request to stay the lower court's order. And I'm going to read you some chunks directly from the opinion, right out of my Abrego Garcia binder, because it's a pretty stunning opinion, and I think you should hear it firsthand. It's also not that long, so if you want to look it up, I would recommend doing so. You can find it by searching for 25-CV/00951 and looking for the order that was issued on April 17th. That's today. So the court says, while we respect the executive's robust assertion of its Article 2 powers, I mean, if you guys have heard anything they've been saying lately, it's, we have Article 2 powers and they let us do pretty much anything. We shall not micromanage the efforts of a fine district judge attempting to implement the Supreme Court's recent decision. So that's pretty straightforward. But I'm going to run you through some more stuff here. It's difficult in some cases to get to the very heart of the matter, but in this case, it is not hard at all. The government is asserting a right to stash away residents of this country in foreign prisons without the semblance of due process that is the foundation of our constitutional order. Further, it claims in essence that because it has rid itself of custody, that there is nothing else that can be done. This should be shocking not only to judges, but to the intuitive sense of liberty that Americans far removed from courthouses still hold dear. The government asserts that Abrego Garcia is a terrorist and a member of MS-13. Perhaps, but perhaps not. Regardless, he is still entitled to due process. And this is important because a lot of you have pointed out, oh, doesn't something say he's a member of MS-13? Doesn't something... I am not totally sure because, to be honest, the documentation is a little bit fuzzy. But the point is, those are questions that need to get answered in a court. So then they get into this whole question of what the Supreme Court said. And the Supreme Court said that, they don't have to, or that, well, there's a question about whether or not they have to effectuate his release, but they do have to facilitate it. And what does that mean? So the court says here that by using the word facilitate, that would allow sensitive diplomatic negotiations to be removed from public view. So if we've got to talk to Guatemala in private, fine. It would recognize as well that facilitation of Abrego Garcia's return leaves the executive branch with options in the execution to which the courts, in accordance with the Supreme Court's decision, should extend a genuine deference. They should let the executive branch figure this out however they want, but they have to figure it out. That decision struck a balance that does not permit lower courts to leave Article 2 by the wayside. But the Supreme Court decision does not allow the government to do essentially nothing. It requires the government to facilitate Abrego Garcia's release from custody. Facilitate is an active verb. It requires that steps be taken, as the Supreme Court has made perfectly clear. Thus, the government's argument that all it must do is remove any domestic barriers to Abrego Garcia's return, which is what they actually said in the motion that these guys are responding to, is not well taken in light of the Supreme Court's command that the government facilitate Abrego Garcia's release from custody in El Salvador, and that's in italics. The point here is that the government's been saying, well, facilitate, that just means, we got to buy him a ticket if they'll let him go, but they won't, so there's nothing we can do. And the court here says, no. Now, facilitate does not just mean let it happen. It means you go make it happen. You can just figure out how you make it happen. Then they get into a little side thing where they talk about the differences between courts and executive branches, which they'll wrap up in a second. So I'll give you some of the examples. They talk about the fact that, the executive branch is very high energy. The court is frequently attuned to caution and often uneasy with the executive branch's breakneck pace. But there are more differences. The executive is focused on ends. The judiciary is more focused on means. Basically, they're just saying, we understand that the courts and the executive branch are very different places. And then the executive branch possesses an enormous amount of powers to prosecute and to deport. But with power comes restraint. If today the executive claims the right to deport without due process, what assurance will there be tomorrow that they will not deport American citizens and then disclaim responsibility to bring them home? And so then they're going to go into this whole thing about, U.S. and El Salvador both saying, oh, we don't know what to do. We are told that neither government has the power to act. The result will be to leave matters generally, and Abrego Garcia specifically, in an interminable limbo, which they say is unacceptable. So we're back to the differences between the branches. The basic differences between branches mandate a serious effort at mutual respect. We got to respect each other, guys. The respect that courts must accord the executive must be reciprocated by the executive's respect for the courts. If we're going to respect you, you got to respect us. Too often today, it's not been the case, as calls for impeachment of judges for decisions that the executive doesn't like have sadly illustrated. So they're really calling out the executive branch here and the president in particular. And they say, we are reminded of President Eisenhower, who, contrary to this, in another situation, expressed his belief that the very basis of our individual rights and freedoms is the certainty that the president and the executive branch of government will support and ensure the carrying out of the decisions of federal courts. But if the branches come too close to grinding against each other in conflict, this is a losing proposition for everybody. The judiciary is going to lose a lot of its legitimacy from constant suggestions that they have become an illegitimate branch. The executive will lose much from a public perception of its lawlessness. The executive may succeed for a time in weakening the courts, but over time, history will script the tragic gap between what was and all that might have been, and the law in time will sign its epitaph. They say it's possible to see this case as a crisis, and as I've been talking about whether or not this is actually a constitutional crisis or not, I'm glad they bring this up. We cling to the hope that our good brethren in the executive branch perceive the rule of law as vital to the American ethos. This case presents their unique chance to vindicate that value and summon the best within us while there is still time. With all this, we deny their motion for pending appeal and writ of mandamus. So, that is that. It's a harsh case, a harsh opinion, but I thought it was important for you to hear it right from their mouths. Keep following to stay on top of things. And check the link tree in my profile for other places to follow me in case this disappears, or ways to support me, because I could use the support. Thanks.